Hi, everyone. Carl Steinbeck here. Wednesday night, I want to cover day 11 in the Massachusetts versus Karen Reed case. And I want to cover something that I think is very explosive on this case. I think it's a bombshell. I think it's something that could blow this whole case wide open. I think there's an issue here we need to pull the thread on and talk about it tonight before we cover any of the rest of the coverage that was today. We saw live streaming right there in the Denham County Courthouse. And this has to do with the shoe, the tennis shoe that John O'Keefe was wearing the night in question when he got murdered. And so I want to go back to last year's trial and let's see how they introduced this one of his shoes there. So stand by. Here's Sergeant Buchanan.
Another item certainly recommends that.
Yes, it's the right sneaker recovered from the hospital room.
So this is right
Your Honor, with
sneaker
court permission, if the witness could remove that item from
Yes.
the
in the
bag.
hospital room.
Okay.
All right, let me jump ahead. They're getting out of the bag. Wait till we see this here. It's not letting me forward here on the. Here we go. Here we go. Let me back up a second. He's pulling the shoe out of the bag. He's right. Look at the white soles. All white at the bottom. And he's saying that's the one that came off his right foot.
All right, Mr. Lally.
Yes, thank you, sir. If you could return that to the back, please. I'll introduce in a minute.
Yes, I'm going to. Thank you.
Okay. No question. They're saying, they didn't have an evidence log. There's no direct chain of custody they have to prove that was what he had at the hospital. So, but that's what they're representing it to be. And so let's go then to what we had here today. They introduced the other shoe today with a different officer. Let's go look at some of his testimony here today, see the difference. Oh, sorry, I got the wrong one there. Here we go. This is Connor Keefe.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes,
Do you know about what time you went there?
approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes,
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search, very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag
And why would you do that?
to secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please.
Okay, there's a
Trooper, do
black,
you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
you can see,
Did you see that item that night?
now notice the black sole there. You see the Nike swoosh upside down. You see some snow along the white side of the sole, but then you definitely see a black sole there. All right, that's not a white sole, and that's not a photo issue. This is very clearly not the same set of shoes.
Yes.
74A, please.
But there's another photo even better.
74B.
That's a distant one.
Thank you.
Okay, there's an even better
Is
one.
that-
This nails it right here. Look at that is a black soled tennis shoe. Okay. They have two different shoes that they've presented in trial. These are not the same set of shoes.
The same sneaker.
Yes, sir.
Yeah.
Even said it's the same sneaker that he's got in this bag here that he's about to present.
If you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence. Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
They act like they're handling the evidence just the exact chain of custody they're supposed to. There's no evidence log showing how this was passed from hand to hand to make it to the evidence room in this bag. They didn't say when they put it in the bag either. They did not put it in the bag at the scene like they're supposed to.
Sorry.
With the court's permission, can he show the item?
Yes.
It's almost like he's got the intent of not showing the bottom of the shoe. but he's
Trooper, is that the same
very
item that
gently
you found
putting the
that
bag. You
night?
can see it.
Yes, sir.
It's all white
You can
shoe.
place it back in the bag.
There's no edge along the bottom. He's acting like Vanna White here, just holding it up or something, or somebody on The Price is Right, just holding up an object, and with the gloves on, it looks pretty corny. But that is a different shoe, folks. Completely different shoe than the one they depict on the photo there.
I'd ask this to be marked as an exhibit.
All right,
Watch
any
as he's
objections?
putting it back in the bag. Very quickly. Putting the bag very quickly. So let's go back now to the one there at the scene.
If I could begin, I'd like to show you on the screen. Do you see that item that night?
Yes.
From that angle, it's a black.
74A, please.
That
After
angle
your-
is definitely a black sole. So the question is, does Nike make a shoe that looks like this, that has just the very bottom part of the sole is black? The other really key distinguishing feature on this shoe compared to the one that we just saw in the court today is the heel has this curved up black portion of it here on the heel. I don't know what you call that, when a lot of shoes nowadays, they have this curved heel, and that's a different color. So the back edge of it has this, it's sort of like they have a separate piece of black rubber that they fix to the white rubber, and they curve it up around the back of the heel. So this is a totally different shoe, folks. There's no doubt about it. So the question is, how does this happen? How does this happen where this is what they showed a photograph of, and then in court,
Alerted to that sneaker. Did you place that sneaker into
in
an
court we
evidence
see
bag?
a completely different shoe, and he's
I'm
saying
gonna
that's
take
the same
A
shoe.
few questions. If
Evidence was
Now, where's that black curved up portion on the heel? You don't see that at all. He's got his finger over the heel.
Trooper said the same item that you found that
There
night.
it is. See, there's no
Yes, sir.
curved up heel portion.
can
of
place
it.
it back in the
bottom of
bag.
it's not black. All
I'd
right.
ask-
This is a different kind of shoe. So let me show you something else here. Look, here's the white kind of shoe that they have here. It's a men's tangent sneaker. So that looks very much like the one that we saw in court. All right. I don't know if it's the exact same one, but that's the style that has all white bottoms. All right. Now let me go back and I believe I had a photo of the black, what the shoe looks like, to show that Nike makes a black one. Hold on a second. I got to find it in my docs. Whoops. No, I just lost everything. Oh, man. Tabs and me are not compatible, I tell you. All the tabs you got to open and close and drop and drag, and it's very... So, but this was not brought up in trial at all today, folks. This was not brought up in the last trial. It was not brought up in this trial. These are two different shoes. So let me try to show the other kind here. Anyway, I thought I had it, but I don't. But anyway, there's a shoe that they make, that Nike makes, that does have the black sole like that we saw here. So Yeah, that's not a shadow plant, Enchantress. You can see the black soul going up to the heel area. How's that that a shadow and not the rest of the heel? The complete bottom of the sole of the shoe is all black. It's a thin layer of black all the way around. And so this is not the same shoe. So the question is, how did you have a white bottom shoe in the hospital with John O'Keefe? And then later on that day, they find a black bottom shoe on the bottom of John O'Keefe's, on the shoe that they found there at the scene that they found later on that day when it was dark out. So what happened? There could be any number of scenarios that happened. One of them that I think the defense could say is that his foot got mauled by the dog. There could be somebody else's DNA or blood on the shoe. I mean, defense could have a field day with this, saying that this is reasonable doubt. You actually tampered with evidence here, is what they could allege. Think about what we had seen in the Alec Baldwin case. They merely forgot to disclose some extra rounds that they found at the scene to defense, and there was nothing actually that was tampered with of what they brought into trial against Alec Baldwin. What did the judge do? She dismissed the whole case with prejudice, completely ended the trial, sent everybody home, right? So this is way much more brought before the jury here. So they basically, this is way worse than the inverted video. They actually have a discrepancy between the evidence, and it looks like they did a substitution and was hoping nobody would catch it. And if nobody caught it today, then it worked, right? Nobody caught it today. But I'd heard some comments about this. This is not my own original thought here. I'd heard something about that before, that the shoes did not match. So I was looking for that today. So whoever made a comment some while ago, and I think I may have heard it twice in the last year, you guys get the credit, not me. I was just looking for it. But in any event, yeah, absolutely, Michelle. They are two different sneakers. Two different sneakers. The government cannot explain this away, right? Did they lose the one? Whatever happens, did they get the wrong one from the hospital? Something doesn't add up. It's absolute disaster for the prosecution. I mean, this should end the trial. It really should. Now, with this judge, they could probably get away with anything, and nothing would shut the trial down. Yeah, it is today. This one is the opposite shoe. It's the left for the left foot. The one they showed last year was the right foot. I did not see any video from last year. They introduced the one from the scene. If anybody has that link, could you share it with me? But either way, we have it. They're saying this was his shoe. We got a photograph from the night in question, is a different Nike shoe. And now they're showing one that has all white bottoms, and it doesn't have that all black bottom with a curve up on the heel. So this Susan's saying they never found his other shoe and got a new pair. I mean, if they did that to make up for their botched processing of the evidence, man, that's like a smoking gun. All right, that should end this case. Yeah, it should never have been brought anyway, Melanie Gore, and it should be dismissed. If you got this kind of like tampering with the evidence, I don't, yeah, you know, my Japan, you're saying if they're different shoes, don't you think it would have been pointed right in there? You can't believe the stuff I've come across in my years of doing trial work of what the other side will miss. It's just unbelievable stuff that just blows the case wide open. It's open and shut. And when I point it out, it like kills a case in its tracks. It never makes it to trial. This is the kind of evidence we got. It's like, how do you explain this away as innocent, sloppy stupidity of the police department here? You can't explain it away. You can't. It's tampering with the evidence. And if it's tampering with the evidence, why would you tamper with evidence? Because you're trying to make the case, build the case against Karen Reed. This is like part of a setup, it looks like, right? So can you explain how and why we have two different shoes? Are we going to say that John O'Keefe wore two different types of shoes? One of them has a taller heel than the other one? I mean, seriously? Maybe there was some DNA, like saying blood on there, and that's why they had to get rid of the shoe that they found at the scene. Maybe they had Chloe's DNA all over that shoe and they had to do a switch out. Maybe that's why they ripped his shoe off. I like to see what kind of receipts they had of selling that, if a shoe like that was sold on the 29th of January, anywhere there in the Canton area. None of these bags are printed. First trial. I hate this. Yeah, they don't say. I mean, it's just like everything's just slammed together. It doesn't make any sense without an evidence log. Here's what I can tell you. If you have, like, if I'm defending a guy, let's say I was defending Karen here in Texas. If you have something grabbed from the scene there, you have to have a chain of custody. Every law enforcement official that touches a piece of evidence has to note it on an evidence log, who you hand it to, what time, and you can go on down the list until it finally reaches the evidence custodian back at the police department. All right, so there should be a easy script to follow on how this evidence went from the crime scene all the way back to the police stations and the evidence room. And the evidence room, if it's going to leave there, then they got to add another entry of how it's brought to the courthouse for trial. And then it has to be in their possession the whole time. Then they have to return it back to the evidence custodian. So it has to be, it's almost like the certified registered mail in the United States. It has to stay in a safe unless it's moving and somebody has personal tracking for it. It's almost like you can track gold that way. You know, $10,000 of gold would be tracked that way. Somebody is signing for it at every stage of the proceeding of it being moved and transferred in the U.S. mail system. Same kind of thing for evidence. You have to have that kind of tracking on it. And guess what? If there's a glitch in the system, that person's responsible. So here it's like it's just a free-for-all. There's no accountability. There's no checking of anything. So the one workaround for that, if the defense would stipulate, hey, we're not going to stipulate, we're not challenging you on the chain of custody. Just like look at the videos you have of Karen. The defense is not making them prove it up in court and bringing in the videographer, photographer, or whatever they had to record her statements that she gave to the media. The defense is just stipulating for that. So that's one thing that's oftentimes done just to not drag out the trial, calling custodian of records. And over the years, they do have authentication statements that people can give. That doesn't make somebody actually be brought into courtroom and testify in person. But the other way is like if something's readily identifiable, like it's so unique that you don't act, then you could get around the chain of custody requirement. So if you had like shoes that had certain markings on them, or you had some kind of signatures on them, or let's say you had some, you had your initials. If John O'Keefe had, J.O.K. on the back heel of his shoes written in a black Sharpie or something like that, something that's uniquely signature to that piece of evidence, then a chain of custody is not going to defeat that coming in. But here it's just like a free-for-all clown show, and nobody knows what's going on. The left hand doesn't know what the right hand is doing. But when you have something this huge of an issue where you don't even have the same tennis shoe that's represented from the crime scene to in court, this is to me, it's open and shut. I don't see any way around it. And so the fact of the matter is you have the black bottom shoe of a Nike that looks very similar. It looks like there was a substitution in play here. That's what it looks like. How else do you explain that away? Now it's not a picture issue, okay? It's very descriptive. You have more illumination because of snow. It's very new. The lace is undone. So you tell me that John O'Keefe was walking around in snowy, wet conditions with loose laces as well? So going back, let's see. I want to show this one more time. Let's go back to last year's was Buchanek.
And Your Honor, with the court's permission, if the witness could remove that item and display for the jury as well.
Yes.
I guess that's different. Next, so we'll go back.
437. Yes.
That's the other
Objection.
clothing. Sorry, I missed my spot here. Hold on a second.
After viewing Mr. O'Keefe's body, we proceeded to identify the clothing items.
I just want to see if this. Okay, here I think was that break we had with and folks
On top of each
Work, individual.
was a black and gray.
I want to get him to show the shoe
Fine.
again.
What if any?
I'll go to an email here. Stand by. Okay, here's one. Here's. All right, here. I want to show you this first. Okay, here it is. Look at it. That's what we saw, a shoe like this in the photo there. That's what this one is here on the left, right? That's totally different than what they presented in court today. And for the right foot that they took off John's body at the hospital, that's also a white sole shoe. So it looks like they realized we got to match the shoe. You can't have a black soled Nike brought into evidence. I mean, that's going to be too weird that they had a white one in last year's trial. So it looks like this is the kind of shoe here. And I'm sure they have many other different kind of models, but this goes to show you that Nike does make a shoe that that has this wrap around up the backside of the heel type with a thin black sole. Most of it's white. It also looks like it has a thicker white, like it has a higher. If you look up there where the balls of the feet are, and then you compare it to this Nike, so it looks like it has a taller height profile than the other shoe that we saw in court today. So that pretty much also proves it right there, folks. So I just don't know how, I don't know how this was not caught. I mean, it's little details like this that completely blow up in a case. So explain it away, government. I don't know how you explain this away. This is so serious, folks. Am I just missing something? But I'm just going by what I saw in court today. This is video feeds that we got off of YouTube. So Susan saying jury's probably so confused with all the craziness they didn't even notice the shoe. Little stuff like that, though, folks, can trip you up if you don't have your ducks in a row. And could it be possible that they realized that they lost the shoe and they can't find the exact match and they had to get something? So that's what they decided to do, is just said, hey, go down and get a size 11 or 12 Nike with a white stripe and a black tops and white soles. Well, the problem is, this one is not that exact. It's not a match at all. I don't know. This didn't come out. I thought this whole issue with something with that came out in the other case with Carney about Jen McCabe paying and giving this lady a couch to harass Karen Reed and her fence team. I thought that would somehow be coming out with Jen McCabe. It never did. So this thing here, I mean, this is This is not something that's going on in another case. This is actually going on right now here today. And yeah, you can email if you want to email me something, send it to jurytrialmentor, mentor @gmail.com. So I don't know. This is what it looks like to me, folks. Can somebody else explain? Is there more photos out there? Is there something different? There's more pictures of shoes. I mean, how do you explain this? This is what they presented in court today. There's one on the left here, right? Is that what was they found at the scene? Look, it was dark out when the CERT team went out there. It looks like brand new shoes. I want to see the one. I want to go back to. Hold on. I want to go back to. I want to see if the one from trial one, the hospital shoe. Yeah, let's have a still photo of that. Let's see here. I guess it wouldn't matter if the laces were done. They probably undid the laces to get the shoe off. So that's not going to be indicative. But the fact is, the one they had today, it's pretty amazing because they have the shoelaces undone. So if he got knocked out of his shoe and he wouldn't have been wearing laces that night on a snowy night where his laces get all wet and soggy and he's real particular about taking shoes off. He's not the kind of guy I would think to have shoes off. I mean, the laces undone when it's snowing out. Margaret Friends, you're saying the waterfall, his left shoe had a white sole. Swish looks slightly thicker, but it's there. I mean, these are two different shoes. They're obviously Nike shoes, but they're two different shoes. Well, and like you're saying, obviously, insider goes through the whole thing. It's actually the same shoe she's wearing through. Okay, well, you can't convince me of that. Okay. So anyway, this is something that if I was the defense, I would, Melanie Gore, you have the evidence picture of both. We'll send them to jury trial mentor. I'll take a look at it. Yeah, unless he wore mixed match shoes like that. Patricia Workman, the sole's immaculate, no wear or tear. Doesn't look like he's been out in the storm. Cole, you agree 100%. It's not the same shoe. So yeah, unless he was wearing two different shoes, guys, this is huge. Yeah, Lisa, that's what I'm saying. The one has a thicker sole. Yeah, so that the one looks like a running shoe that we saw there. That's supposedly there at 34 Fairview. The other one does look like a trainer. Yes, I agree. One that doesn't have a higher heel for cushioning and running. Mike, you agree? I mean, maybe Karen's the one that bought him these shoes. Yeah, look like it came right out of the box from a Nike store, as somebody said earlier today in the chat. Yep. Gallagher admitted there's no chain of custody. What's no chain of custody? Guess what that means? You can just, somebody could come in there and freely substitute evidence one for another. And that's what happens when you start getting sloppy and you don't care about chain of custody and logs and all kind of stuff. And then if somebody would want to take it upon themselves to say, hey, we look really bad. We said we got pictures of shoes. We can't find the shoe. What the heck happened to that shoe back at Canton PD or wherever they put it? If they even found one, how do we know that wasn't planted there before the CERT team got there? Because they took it off his foot because they saw it was all bloody or something. Salem, you're saying they're not even trying to make it look believable. I mean, this is just really bizarre. Sophie Girl, can the defense bring this up in closing? This is something that could stop the trial right now. If the defense wants to use it. Okay, Queen Olive, you said to point out different shoes last round. People said black shoes. Okay, well, they're wrong. There's no doubt in my mind they're different shoes, okay? Yeah, it's not the same shoe, folks. If you guys want to say it's the same exact same shoe when it looks, it's not a picture that's got issues with lighting that makes that sole look different from the other one. Julie, I don't see anything. I haven't come across it yet where they challenge us in the first trial. Mo Hippie, you think it looks new and never worn? Yeah, and it's a different shoe. Not only, I think the bigger issue, it looks like a totally different shoe. Leslie Barrett would have had water stains and salt from the Road RX. Yeah, well, if it was discussed months ago, they didn't present it in this trial yet today, did they? So it looks like something was done to clean up a problem. That's what it looks like to me. Yeah, Kate, I'm sure there's trolls that'll say that kind of stuff, right? Look for yourself. I mean, I've been wearing tennis shoes my whole life. So that's what this is. I ran it by my wife, same viewpoint, ran it by John, same viewpoint. This is not something I'm not really sure that's the picture doesn't really do it the clarity that you need to really make the right call. It is a black soled tennis shoe, all right? Yeah. Yeah, so it supposedly got debunked by somebody months ago. This happened in trial today. One right after the other, they showed it. So let's go back to this and let's go back to this Connor Keefe. We'll just go through some of his testimony here today and see what else is going on. But
This to be marked in an exhibit.
All right, any objections, Mr. Unity?
There is no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who's collecting it.
If defense knows, why aren't they raising it? That's my question. If they know these are two different shoes, why aren't they raising it? I don't know.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
It's already been admitted to evidence, as I recall. So, it's the damage has been done.
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
Yes.
Can
Not
the
a-
item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
Yeah, let me show you here again for you guys are asking. All right, this is what we have, similar to what we see here in this. This is the best photo of John's left foot shoe. It's a Nike. You can see the white swoosh. You see a thicker sole on this one that's white. Then it has a black layer on it, and you can see the cup around the heel, similar to this one here. This men's wide fit Nike Revolution 7 running sneaker. So that's a running sneaker, all right, that we see there. This is the kind of one you see in court here, though. This is supposed to be the exact same shoe. Look, it's for the left foot. And this is similar to the Tangent sneaker where it's all white sole. There's no black on it whatsoever. So how do you reconcile those two things, folks? This is a serious issue. I'd be panicked about if I was a prosecutor. I'll tell you that. You could lose a whole case and should lose a whole case over just this one thing as well, unless they can say that John was wearing two different type of shoes that night. I've never met a guy that did that. Yeah, but nothing's been filed in this case here having to do with what the Carney case are mentioning. is things done by the Morrissey prosecutor's office along with Jen McCabe. Those allegations have not been made in this case, has not been brought up at all in this case. Right, sorry, goofed up here. My bad. I am trying to add this video to the stage. Sorry, I thought you were watching with me. There we go. Sorry. This is the rest of the testimony today. All right, let me jump ahead here.
You don't know how it became chipped?
I do not.
I'd ask you to remove that chip. Like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit.
78.
So we're going to mark the little chip.
Waterfall video
You want-
shows
Mr. like to
Giannetti
mark it?
asked to
Okay.
mark
at the
that.
bottom of the left shoe. All right, so if somebody could forward that to me at jury trial mentor, mentor @gmail.com, I'll go ahead. If you can do like the direct, show me the direct timestamp that is.
Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
Didn't bring it up today.
Exhibit
So
BB for identification.
it's never come up
Thank you.
before in court that I'm aware of.
Trooper, we have one more bag of items to go through.
Yes.
Could I have exhibit 73, please? Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
Yeah, they can bring this up. I would imagine they'd bring it up because this could get you the same kind of outcome as Alec Baldwin.
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
So I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
Yeah, I mean, I think this trying to bring it up through witnesses. Hey, this is the right pair of shoe. I mean, this is something that you're talking about. Evidence type tampering issues coming up here, and unless they're going to say that John wore two different types of shoes, one with a higher heel than a lower heel, one's a running shoe, the other one's a flat trainer. I mean, I don't know anybody will be crazy enough to wear something like that. It'd be really awkward. Number one, number two, you'd look pretty stupid. So I don't think John would do that.
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay. There's no objection, Mr. Yannetti?
There's no objection, no.
Exhibit 79.
With the court's permission, could we show exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please? Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items of evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Ms. Giannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Switch it up here.
Yes.
The number you sent me stuff, so thank you. Someone saying look up, try the night court vision shoe. Somebody sent me a Bella 7. That's a women's shoe, though. All right, let me try to add these now. One second, stand by. I'm trying to, I downloaded them and they're not showing up here for some reason. Let me just go to the email, maybe try it that way. Stand by here. Okay, I got to share screen. All right, so here looks like we have an evidence thing of two of the same pair of shoes, and look how dirty they look. So even that doesn't look like what we saw in court today. And you still square that with what we saw at the scene. That looks like a black sole shoe. So here we have two that look the same. They have sort of similar wear. Says that was exhibit 251. Here's exhibit 252. So that looks like the same kind of shoe there. And this photo here, it looks like the same, but so why is the one at the scene looking different? I do not agree that shoe from the scene, let's go back to the one at the scene there. Sorry about that. Let's see here. Yeah, they look like brand new in court today. The heel looks different. Let's go back to. That's not a white soled shoe. I don't think any kind of, look how bright the light is there. You see a little bit of grass there. You see some kind of orange jacket or clothing there. Yeah, these are two different shoes. So yeah, Dusty, you agree? Sneaker in the court looked new, pristine, not worn. So yeah, these other ones look like they had mud on them or something. So sole's black. Yeah, and it has that curved edge around the heel. Well, these ones they have in the exhibits. Thanks. That was those photos are from Melanie Gore, so thank you for that. So yeah, so in the evidence room they have two white soled shoes, but here at the crime scene they're saying it's a black soled shoe. It's just that's what happens when you don't have evidence log. There's no trust and confidence in what the government's presenting. I don't trust any evidence these guys are presenting. How can you? Unbelievable. I don't know what the defense is going to do with it. I'd be if this was my case text, I'd be doing a motion to dismiss. So, all right, let's go ahead and proceed on. Here's what we had today.
Consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach you, Anna?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper.
Thanks, Melanie.
having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
Sorry, Melanie. I don't. This whole issue that they in the evidence room they got two white matching shoes. That does not resolve the issue. It just still remains that the photo we saw from what they gathered at 34 Fairview is a different shoe than what they're showing in court. It's a different shoe. There's no doubt in my mind.
David?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
They're not allowed to clean these shoes up to present them in court. They're supposed to present them as is.
Correct, 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay.
Okay, right there. Subject to redaction. So what this leads me to believe.
However,
Yes.
may I offer that into evidence, Your Honor,
Is
please?
there an objection, Mr. Brennan?
No, subject to redaction.
Subject to redaction. I believe what he wants redacted is the fact that when Jen McCabe turned over her phone, her lawyer also signed off on it. That's the only thing I can think of that was redacted. And I don't know why they're not bringing it up. Maybe they've been blocked by the prosecution in some kind of sealed order by the court that they can't bring up the fact that all these prosecution witnesses have their lawyers in the room when they're testifying.
Okay. So don't put it up on the,
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation. No,
You have not yet.
no.
The lead investigator is the trooper who is responsible for the case, correct?
Coming up here, he's going to tie in this officer with Proctor, and you're going to see some stuff that Brennan does to keep out the truth again.
Yes,
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes,
The two of you have worked cases together in the past, correct?
a few.
You've worked on this case with Michael Proctor.
The shoe that they showed there at the scene, supposedly from 34 Fairview, is the left shoe. The one they got from the hospital was the right shoe. But as the picture shows from 34 Fairview, if that's to be believed as they're representing in court, that is a different shoe. It's not the same shoe.
Proctor, correct?
Yes,
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
you'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Okay.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach you, Honor?
Yes.
Yes. Yeah. I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done.
Yeah, that is true. They could just be lying in wait to see how this pans out and then go ahead and swoop in and go after any of these folks responsible. Nice. Taking a long time to read it here.
And Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you
I'd just
don't
like
have to
to-
brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead. Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
Yeah,
So when you say yes, is it your current testimony that your memory is
he had no recollection of sitting on an interview on this case. He's a junior officer at that. He doesn't look like he's very happy having to answer that.
refreshed that you were actually there?
yes,
Okay. And the two of you would have participated in that interview together, correct?
yes,
But You did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
So that's good. They're weaving in Proctor to being a heavy influencer on this case. So bringing that out in cross-examination, exactly what they should be doing. Proctor pretty much had control over this whole case from the get-go as soon as he was brought in anyway.
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. I may approach Judge.
Yes.
Thank you. You're welcome.
Ani, Lisa, that's the kind of stuff prosecutors can tell their witnesses, yeah, just take your time if you need to read something. And so that can be a way to have the defense be thrown off their momentum, their rhythm, and it sort of looks like, okay, the jury's sort of like, all right, how long do we got to sit there and wait for this guy? And it's just sort of a real momentum killer when you're going up to a guy that should know this report like the back of his hand. I mean, he's coming in to testify on a murder case that's being broadcast around the world, and he can't even remember interviewing Sarah Levinson. That's like so embarrassing, I would think, for him.
Other examples are the reports on the videos that well, strike that. Let me start by saying this. Asking this. You retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach.
Okay.
Yeah, that could be it also. Proctor set him up, said he was there, and Proctor was on his own. Not sure which defense will argue in the end, but
And again, if you read that silently to yourself,
either
you'll
way,
let
it
me
makes
when you're
these
done.
guys look so incompetent. For Proctor's sake, corrupt, obviously corrupt. I think you're right that Hank will not call Proctor. I'd be surprised if he calls Hagen and Albert. I mean, he's got to call Proctor. If you don't call lead investigator on a murder case, I mean, that's pretty damning. It's in a way an admission. I think he's going to try to maybe just get it out in the open and soften the blows. But if you don't call lead investigator, yeah, he may just go off and just say, I'm not going to call any of these. Yeah, so don't know, but no matter what he does, it's going to be a tough decision because either way, he's going to look bad if he's not trying to bring out the similar kind of information that came out last trial and just has the defense call him. If you got a judge that's going to rubber stamp everything you object to, so maybe he's going to try to block the third-party culprit defense that way, which I just hope they don't go at third-party culprit defense. It's just, to me, not needed, not necessary, not worth it. A lot of reading, this guy. Wow. think the prosecutor to have him prepared. So did they talk this over and say, you don't worry about preparation, make the defense present documents to you and just bog the whole trial down?
Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes,
And by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
this is CF McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the waterfall bar and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes,
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes,
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
So just a nickname, you're going to object to that, a first name nickname? So is that what he was called by? I don't know why Hank would object to that, but obviously the judge is right away there to launch an action to help save him. It's good that the defense is being aggressive like this. They weren't aggressive enough the first trial, so they definitely need to be aggressive, have sidebars. Yeah, I think the way the guy pulled out this Connor Keefe cop pulled out the sneaker, it looked like he was trying to hide the bottom and the back heel. It sort of looked like they did that in the first one as well. First trial when they showed the sneaker from the hospital. All these sidebars trying to block the coming out.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes,
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
Yeah, Liam, I think that every Commonwealth witness so far has only helped Karen or had really, or else was neutral, I would say. There wasn't really a big deal. But I would say, like the weather guy, I think that's a little bit helpful to show there wasn't a lot of snow on the ground. And where John was laying, if he's really laying there when it's just basically less than an inch and he had his body warmth laying on that spot, there would be a clear patch of green grass where he was laying. It'd sort of be like a mark out where they show like dead bodies you see on movies and stuff like that, where they have the outline where the body was laying. That's what you would see there in the snow. And we never saw that. So what does it make it look like? It makes it look like he was placed out there after a lot of that snow arrived, sometime closer to 6 in the morning, much closer to 6 in the morning than it was around that 12:30-ish mark.
he could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022.
So look at that. Here we got, and I mentioned something on X today. Here we have that we're on the 11th day in court, and we still have not had the autopsy photos or the manner of death presented to the jury. we only heard from Hank talking about how John was hit by a car and he fell back, hit his head, something along those lines. This very, very quick summation that way. But the jury's still sitting there thinking, oh, how bad does this guy look? What's going on? We should have seen autopsy photos within the first 2 days, at minimum, first 2 days, I would say. So instead, you have all these little clips of Karen talking, and it's just really such a disjointed case. And I think it really shows the momentum that Hank realizes he doesn't have. As soon as he shows the autopsy photos, he's going to lose whatever momentum he thought he has. And right now, I mean, he's tanking every day. He's not doing good. Every day, he comes up with more reasonable doubts. He's presented through his witnesses. So his witnesses are building reasonable doubt, and got a pretty good pile of it right now for Karen Reed. So they got nothing. They got nothing as a strong witness to really like slam the door shut and say, yep, this is what happened. No doubt about it. The prosecutors don't even know what happened. They're just trying to pull stuff out of thin air, and it shows. They're trying to come up with a new theory, a new timeline. They changed the timeline in the first trial from the opening to the closing, and now they're coming up with a different timeline in this one. You don't keep changing the timelines like that unless you were just really guessing at what happened. So this is why I think every day Karen has a momentum on her side, and the jury today, they're really, I think, listen to all this technical stuff with this expert that the prosecution called in the first trial was really such a bore, and I think it was pretty much more confusing for the jury than anything else. But I'll get to that here in a minute.
And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
And
Now he remembers that very clear, so he doesn't remember with any clarity whatsoever that he attended the Sarah Levinson interview.
Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know?
So Hank is mad because he's not the first one bringing up the autopsy. This is great move by the defense. Bring up Proctor, bring him up with the medical examiner, and it just shows that Hank knows the autopsy photos are a big loser for his case. That's why he hasn't presented it. And now defense is the first one talking about an autopsy, and then he's going to be objecting here. Watch this.
Know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said.
Objection.
See,
With regard to
there he is, an objection, sustained.
Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Sustained, you can ask that differently.
What, if any, conversations did you have?
You know, all these conversations, Hanks gets in, and there's no defense objection, and then he's just trying to bring up what was happening in the conversations with the medical examiner, and Hank's going to object. Just, again, the truth has to stay out for them to get a conviction.
With Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory.
Of course there was a theory. That's what they do. The cops go on and describe what's going on from the evidence they've collected. They talk to the medical examiner. They try to help shape and influence the medical examiner report. Look at that. He doesn't want to talk about that.
To her, correct?
I did not provide a theory.
You learned at the autopsy from your
Notice he says I. He didn't say Proctor didn't.
observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
Do you want this one back?
Oh, please, thank you. So I've placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked.
He's not comfortable. He's not happy to be there. He's scared, nervous. And he's aligned with Proctor. He's cringing over that idea.
Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Sustained.
You knew when you left that Dr.
Why would that be objected to and sustained? The cause of death was undetermined. It could go to effect on listener or what he was supposed to do to come back to find out about it. I mean, why would you object to this? Because he knows this medical examiner is not in your corner. This medical examiner is going to be called by the defense because Hank knows, again, he's got damage control issues, serious damage control issues. He knows he's trying to prop up a loser case, and that's what he's doing. He's trying to object every chance he can. Think about it this way. That's what a defense is doing. Objection, objection, objection. They're trying to keep out the truth that leads to a conviction of their client. Here you have a defense attorney acting as a prosecutor now. So he's doing the same thing. Object all the time because you want to prevent the truth from getting out there. So he's just switching roles. And this time the truth is not on the side of the prosecution, but he knows that role to do. So he's going to keep objecting, even though it's denying Karen Reed a fair trial. And what I do when I have opposing counsel like this that object all the time, I call them out in my closing, say, you heard how many times they objected. They don't want the truth coming out. So that's my ultimate way at the end to try to get some payback.
Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
Sustained.
You knew when you left.
Wait, you're objecting even to the injuries on John O'Keefe that you saw there?
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
Sustained.
He's right there as an eyewitness to that. So, and this is going to be objected to. This is just such a garbage trial. It's so disgusting, folks, to see these kind of objections.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of question.
Sustained.
You know, the first time
Maybe
there's an
approach.
objection for me, I'd be going up for a sidebar. I would not be tolerating this cutting off the knees and just start blasting away on how you're being denied a constitutional right to present a defense. And that includes cross-examination. You know, one of the things that we saw from this judge is she's blocking the FBI retired agent Easter talk about what a botched crime scene investigation this was. And she denied him, saying, well, you can cross-examine the government and witnesses on improper police procedures. The jury has a general understanding of all that. So you don't need to call an expert. I'm going to deny you an expert, right? So here, when you're trying to show what they're just merely what they're doing in terms of what they saw at the autopsy exam being done, the prosecutor's even objecting to what was happening at the time. So you're just being cut off left and right. And that's why you're not getting a fair trial here, Karen Reed. So if she gets convicted on anything, I guarantee it's an automatic bust on appeal. It's going to get reversed.
Jurors, feel free to stand up.
Prosecutor. All right, so now let me jump ahead here. I want to go to my notes first. So stand by. One second here. Yeah, so we had 1, 2, 3, 4, 5, 6 before we had this sidebar where Yannetti went up there and challenged it. And then there's another objection when he asked, you left without her ruling a homicide, correct? That's 7. So that's 7 objections. Every single one of them sustained. Then we had, let me jump ahead to this Jessica Hyde.
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
It's the same thing, just ask them different.
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
Trying to.
And in order to do that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
You don't know
I
that?
don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there.
All right, let's move ahead. All right, here's a Jessica Hyde, and she's a digital forensic examiner. She's from George Mason University as an adjunct professor.
To find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say in Maryland.
So what he's talking about here is there was a Maryland decision that came out recently where something that this Jessica had been testifying to was considered not reliable by the court. And so he wants to bring that in. And so let's go listen to some of that.
You tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone.
That's good. Thank you, Nick, because today was their deadline that they had to get it done. Otherwise, the judge would have probably stricken that additional testing that they did.
Can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate.
You know, these hearings with these judge on the law, they just last so long, and the prosecutor drags it out, and he's always putting a spin on stuff, both the law and the facts, and it's just really, really painful to watch. And the judge doesn't control the timing and tell them to move along and make quick decisions, because there should be pretty quick decisions on a lot of this stuff because it's guaranteeing the right of a fair trial for the defense. But it's like she'll never tell the prosecutor, "Are you done yet? You need to move along. You got one more minute. I pretty much know the direction this is going to go."
She's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument.
Well,
Well,
it does have to do with the court finding something she had testified to or wanted to testify to was not reliable enough to be used in court. That's my understanding of it. I've not read the case yet. They did not cite the case law here.
To say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated.
Anyway, let's go to this witness.
They're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion. It wasn't this methodology for the opinions that she's going to offer in this case. And so if you look
she's just not a good witness for the
issue. I have the right respectfully to cross-examine on the issue that.
So this is outside the presence of the jury. This lasted a while, and it was really, really tough to watch. Let's see what happens.
They're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask?
All right, let's go ahead. This is the government's expert. She's the one that's trying to say this 227 search on Jen McCabe's phone did not happen at 227.
Be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on.
So she has her own business. And to me, when you have an expert and they're their own business owner, I think there can be an issue where it's sort of like the more they are helpful to one side, the more they can get more business. So I think it's better when it's like with ARCA, where they're just an employee and they're just testifying to something they do, and they're not the owner of the business, and they're not directly so profit tied into what their points of view are. So here she's the actual owner of this business. And she also talked about how she did a brief on some other case in Massachusetts that had to do with something involving IT. And she thought she wanted to let the court know what she thought of it. So it looks like she's really trying to do what she can to do this a lot for business. And one of the things that hasn't been brought out is like how much she made doing this for the prosecution. So that has not come out. And I think that would be important to know, especially since she testified in the first trial. She's testifying in this trial. So she's gotten double the money, most likely. And this is going to be something that I think can shed light on the fact that, hey, there is a money motive to experts that you need to extract, because it can impair their objectivity and neutrality on things. At least you can make the argument to that, right?
In terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Yep.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken.
Hey, Nick, back to the shoe issue. You're saying the shoe looks black because of the picture. Defense not worried about. I don't think so. I think a lot of people we've had on tonight here, we're just going by what we saw in evidence presented today. It looks like two different shoes. It looks like the sole's different. We found some shoes that are similar to that Nike sells that do have the black thin outer sole for the one that we saw that was in the snow there. But anyway, that's what it looks like. And if defense is going to use that, I thought it might be helpful. I think that's what, if they're trying to say that Karen was set up, could the shoe be an issue here? I would run that to ground. If you're saying they've already run it to ground, I just I'm not going to question what they're doing here, but it does seem to me like that could be something it could definitely get some mileage out of, based on the different style of shoe and the different colors on the bottom of the sole.
In multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
And this goes on and it gets
I want
so
you to just give us some
technical and
very
boring.
basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on?
Okay, she went on to say that when she was asked, "Do you have an opinion by Brennan whether there's a user deletion from the phone log earlier that morning?" She said, "Yes, my opinion is that the system deleted the 201st call every time a new call is received or outgoing, and it wasn't clear that the user deleted according to her." But I think it wasn't clear what she was talking about, because it's like, you're telling me you can't delete a search that you do on Google. You cannot have that delete option, and you can't delete a phone call. I mean, I understand there's some other place in the phone, in the internal workings of the phone, that maybe it's still somewhere saved. But anyway, she was just really not making a whole lot of sense. I know also she said, what was that? It's interesting also that Hank asked for the photo to be taken down today. They should realize that as well. Hold on a second here. She talked about, there was a term she talked about that technically was not accurate, and you could even Google the answer, and she was wrong on it. It had to do with some kind of signature on a hashtag, not a hashtag, something like a term like that. And she was originally contacted by Lieutenant Tully of the Commonwealth to focus on two search terms. So the 227 timestamp, and she also testified that she believes that Cellbrite moved the 220 timestamp because it was inaccurate. And to me, it's like, why is Cellbrite allowed to tamper with evidence? They should not be removing anything. So that whole thing is like really strange, that the government is hiring some firm to do research on, hey, when was this 227 How's Long to Die in the Cold? When was that actually search performed? And so she's then using software, and also we heard that Whiffen, the other expert for the government, they're using a software system that removes timestamps. I mean, that just seems really bizarre. So she said it was the search about the How's Long to Die in the Cold was made on a tab that was open at 227, not this actual search. So this whole kind of thing is just really seems bizarre. So you never, if you open one tab and you keep on opening that tab, there's any other follow-up searches in that browser always have that original time? That doesn't seem to make any sense. All right, then on cross. Yeah, she's been paid by the Commonwealth since May of 2023. Yeah, the rest of this kind of stuff, I didn't think that there was a lot of stuff, other than the fact that towards the end on cross-examination, she admitted that she would have had the phones that she was looking at, John O'Keefe's phone. She would have had, and also Jen McCabe, she would have had them in a Faraday bag. So what happens is, like, John's phone kept active until noon of that day. And that means it was not placed in a Faraday bag or box or any kind of airplane mode. That means the best practices for this type of evidence collection was not proper, because you have the ability to affect what's going on the data if you don't have that thing in a Faraday type bag to prevent an outside, like, intrusion affecting the data inside. So I think we've all heard that if you go on like a Wi-Fi at some kind of other business or hotel or something, that they can, it's easy to get your system hacked by going in onto a non-secure site like that. All right, let me go to this part where I thought was interesting. 456 into this.
One of my functions is to make sure that it clears.
You are unmuted.
All right, jurors, as you know, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently, and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I can, but.
Frustrated lawyer. She's only gotten mad at the defense every day. How many times a day is she mad at the defense and something they're doing, either with the sidebar? She's mad at them. Jurors can pick up on that, some of that too. If the judge's body language is like always scolding them, which appears to be the case, but for her to stand up and talk about this is only induced because of the defense saying something like what I've been saying is, like, if a judge is treating you this bad in front of a jury, you need to call out the judge, because it's having a detrimental impact on your credibility for the jury. If the judge is always overruling your objections, always sustaining the other side's objections, it makes it look like you're absolutely incompetent. It looks like you're just trying to stonewall the justice finding process for this case, and it just leaves you out there with a big credibility gap. And the prosecutor automatically, I believe, always has a credibility advantage starting out the gate anyway. And then through this trial, the judge always, the way that she has her negative tone towards the defense and saying, move along. She's basically always chiding them and being derisive towards them for the way they're trying to defend Karen. And that's just it looks really bad. So that's why I think defense at their sidebars, like I would be doing, I'd be calling the judge out all the time on the way she's coming across, acting like she doesn't like the defense, and it has a prejudicial effect on the defendant.
If I seem to cut somebody short, the lawyers are just doing it. When they request sidebar conferences, they're just doing it. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just.
Oh, she's going to try to keep the sidebar conference to a minimum. In other words, yeah, okay, don't take it personal when the defense is constantly having to ask for a sidebar. They're just doing their job. But, oh, by the way, I'm going to try to move this trial along, and I'm going to try to keep them to a minimum. So it's really, she's sort of like saying, on one hand, they should be doing it. On the other hand, she's saying, I'm going to try to keep them to a minimum. So, okay, well, one of the ways you could do that is just saying overruled when the prosecutor objects. So anyway, I thought that was very interesting. And I think that's only coming because the defense objected to the way she's treating them in front of this jury. right, then they also Hank played interview clip 15. Yeah, there's so much technical stuff here. I think the jury was just checking out. So it's Alessi did a good job crossing her, bringing up different points, but she'd also correct him and say, no, that's not how it works and stuff like that. So Alessi here, super brilliant, smart guy. But like I say, she wasn't even correct on some rudimentary knowledge type things as well. So I just don't see how a jury would find her credible. And let's see what the defense has to rebut that. All right, let's go. Let's see. I want to find that spot here. Here we go.
May I?
Yes.
I would like to play clip 15, please.
Another one from ID docuseries.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Say that one more time.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Okay, here we have a statement where Karen's looking pretty cold and assertive and aggressive on that.
Folks, I talked to the.
And she's talking about either she's going down or Jen McCabe's going down. So I think when I initially saw that, it's like, oh, that's not a good thing to say, talk about you going down. And it's either you or the other person. I mean, what is that, like a 50-50 type scenario? I don't like hearing, if she was my client, I wouldn't like hearing my client say that. But I think the way it's played out in this case is that all these statements that Hank is introducing, they're such short clips. I think the jury can pick up that there's more context to this. There's more of a scene setting type environment that we're not getting that kind of information by these short snippets. And it's just like he's sort of like trying to clip at her heels. It looks sort of like a, I don't know, it's sort of like a little tattletale type of thing that you saw in grade school, or somebody's always trying to tattle on folks to try to get in good with the teacher kind of thing. That's what it reminds me of. And when you see these atrocious witnesses for the prosecution, especially Jen McCabe, I think they really get it. They get it now that, you know what, Karen, she didn't intend to kill him. She was upset that night because he didn't show back up out to the car. It was getting late. She's tired, wants to get back home. Snow's not bad at the time, but it's snowy out. And so she decided to go, fine, if you're going to be that rude to me, you don't come out after 8 minutes or whatever it was. She just said, fine, I'll go ahead and leave. And then lo and behold, he's not coming home, and she's mad at him. She's had too much to drink. So all this kind of stuff is like normal behavior for her, given the fact that John was starting to backtrack from any kind of commitment to her. She wanted a full commitment from him. She's worried about him not coming home because he found some other gal, either at 34 Fairview or somewhere nearby there. So she acts totally, going ballistic on him, like it would be expected under those circumstances. And then that turns to fear, and she's very afraid then that something bad might have happened because he never showed up when she woke up there. I think it was like 4:38 is when she first tried reaching out to him again. So anyway, it's I think all these little micro clips are actually hurting Hank. I think that's why he's not presenting the autopsy photos. He's trying to do this drip method of bringing in all of her statements. Remember, we heard there's like 44 of them that she's given to the media. So now we've gotten through 18. So we're not even halfway done with all these little snippets. So I think in the end, it shows her to be sort of like an aggressive, defiant to what's been done to her, the way she's been falsely accused of this. So And that's sort of like the persona of people in the Northeast. They're very much assertive. They're not the kind of people that are afraid to speak their mind and let you know how they really think and feel. And that's part of her in that culture. So, I'm from the Midwest, and people are more reserved. They're not as likely to speak out about things being done wrong. But they're in the Northeast. That's their mindset, and so you always know where you stand with them. And she's letting them know where they stand with them. And again, it brings up Jen McCabe, just like they brought up another clip yesterday where she also brought up Jen McCabe. And so Jen McCabe, like I've said, is the main theme throughout this whole case for the defense. She's the one that really helps show where the defense is focusing on, because she had so much ability to control what was going on. Not only that night John was murdered, but also what was going on in the days and months and years after that, where she's even, like we saw, calling Carrie Roberts up the morning Carrie Roberts is going to testify. So that's the amount of control she's trying to have on these witnesses. So it remains to be seen how many other folks from the House are going to testify. Is the judge going to try to block all these other witnesses from the House being called by the defense if the prosecutor doesn't call them? So it's I think the general mindset is they don't want to bring out these guys to the House too much, because it's really, I mean, as bad as Hank's doing so far, bringing people in the House out, it's going to get even more of a issue, because these are the people that defense are claiming are responsible for John's injuries. So on one hand, if the prosecutor doesn't call him, it looks like he's trying to hide them from being exposed in court as suspects. And so the fact is, if he doesn't do that, defense calls them, then they can treat him as hostile witnesses if they don't want to answer questions properly. So, and it's just really bizarre. If you don't call the owner of the house that John O'Keefe died at, it just really looks bad for the prosecution. And I would make a lot of hay of that as a defense counsel. Also, what Higgins was doing that night, and the fact he showed up at the police station, it was under the supposed reason that he had to move vehicles around. It just doesn't add up. None of this adds up for the prosecution. It's all full of reasonable doubt. Farrell, you're saying just like Whiffen, the trial's a big ad for their personal businesses. Yeah, I think Whiffen probably gets enough with Selbright, but I think this one's really trying to grow her business. Yeah, that's another thing, Kim McDonald. This judge does not like ruling from the bench and doesn't really give long, detailed written orders anyway. But she could rule from the bench and always back it up with a written. But okay, my crime time. You're saying the Nike shoe in the snow is not the same as on the stand today. Nike production of the ones on the stand today are 2023 editions. The ones in the snow are Nike Revolution aircraft production 2022. That's interesting. I just think there's something to this, guys. Defense may not, don't know, but there's really something to this. You can't convince me that's a bad photo of those tennis shoes out there in the snow. They sure looked a lot, very much cleaned up compared to what we saw in those evidence photos. JC, you're talking about Jessica. She said John's phone hadn't been white, but it did admit it could have been altered and manipulated. That's a big deal, right? I mean, potentially it could have been altered. I mean, if I was the defense, I'd argue that, this was in the custody and control of Proctor. So anything Proctor had custody and control of potentially could have been manipulated. But so, yeah, I think defense can make some hay out of that. But I think a lot of stuff was so technical that a lot of the jurors may just sort of like checked out. I heard from folks saying the jurors are sort of like rocking back and just really bored with what's going on. Yeah, most of the defense evidence came from the FBI. Yeah, they had like 3,000 some pages. The Commonwealth's investigation was not an investigation. My father's alibi. You're saying ARCA employees are evaluated regarding promotion by the number of billable hours they charge. So I think there's still financial incentives for those experts. Well, they're having businesses and government agencies hire them, and then they're just going to go do the work. They don't have to go lobby for work like this. This Jessica Hyde, she's actually like trying to put her name out there in a middle of a court case to say, hey, she's like a friend of the court, they call it. It's like, hey, here's what I think you guys should rule on. So that's to me looks like she's very much trying to drum up business. ARCA employees don't have to drum up business. They're not. You think Dr. Wolf and the other guy are told you need to drum up business and help keep this business profitable? No, they get some big federal contracts that and insurance companies and all that kind of stuff. So they're not worried about making an opinion be slanted to help drive up their business. I just don't see that at all. And if they were skewing their rankings based on who the customer was and how much they're paying, then they would lose a lot of credibility pretty fast. Yeah, I'm not going to go back to that chart. You guys can go look at that. Let's see. Operation, you're saying so much or less he got on his high day. It was great for the defense. It was becoming a theme. Defense is stealing the Commonwealth witnesses and putting them against each other. Brilliant stuff. If you have an innocent client, that's what you do. You basically flip every single prosecution witness to your advantage. Neutralize them at worst, at best. You flip them and get some gold nuggets out of there. So yeah, PJ, everything about almost every single witness has reasonable doubt just coming out of the woodwork. Yeah, keep it clean on the channel. Don't like people being called names, picked on, that kind of stuff based on their looks. So what I say is I'm trying to keep this channel where it's courtroom level professional. So if you wouldn't talk like that in front of a judge, then I prefer to have the same standard here. My crime time, you're saying Jessica Hyde methodology has been rejected by 3 other courts and 2 convictions overturned by the Supreme Court. Jessica Hyde also inserted herself via Ian Whiffen. Hyde and Griffin worked together. Yeah, she also complimented Whiffen, which I thought was interesting. I'm not sure I would have done that if I was defense, but they must have some kind of reason they're doing that. Stand by here. All right, let me summarize one other thing here. Let's see. So the ruling, let me go to the ruling then on this issue about whether this Maryland decision against this Jessica High is going to come in or not.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated. Court is in session.
The host would like you to unmute your microphone. You can.
All right, I appreciate the time. I appreciate people's patience. So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross.
So our court found that she was doing something that was not reliable, affects her methodology, being credible or not, that can't come in. Again, you got to keep all this stuff, the truth out, in order for the prosecution to win this case. Yeah. All major rules for the most part, she's finding ways to try to strangle the defense.
Cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
You are unmuted.
Chrissy, do you want this under that?
Yeah, they need to keep filing for reconsideration. I mean, this whole issue that they're going to try to limit everything about the autopsy that was done by the medical examiner. Apparently, they're not even going to call her. They got their own other medical examiner they want to use, or maybe just a neurosurgeon type guy that I believe that's a guy from Miami. They're maybe going to use him instead of medical examiner that actually did the autopsy for John O'Keefe's body there. So it's like they're going to do anything they can to keep the defense from presenting a fair case. Dusting off law books, been serving solitary confinement. Yeah, I don't need to call the defense. I think they got their hands full as it is right now. And anything that I say on this channel, if it's helpful, maybe they have all those students that are probably trolling around different channels trying to get ideas, feedback, what's working, what isn't, from all the different YouTube content creators. It sure seems that way. She shouldn't be consulting with Morrissey, the DA, but it sure looks that way. I mean, this is the worst case I've ever seen with a judge being so pro one-sided. You know, it's one thing if a judge is pro one-sided on a civil case. Here, if you're pro one-sided towards a side that's trying to defy and reject and trample on constitutional rights. I mean, this whole thing is being done in vain. You guys understand that? This case would be busted on appeal. So, and if she's convicted, it's not going to withstand scrutiny. It'll probably be reversed within a year and a half. So, it's going to be automatically busted. If it's not by Massachusetts, I don't have a lot of faith and confidence in anything that I'm seeing for these Massachusetts appellate decisions. Very restrictive on ability for defendants to present a defense, despite the fact there's Supreme Court case law on it and plenty other federal decisions. So they just have a different way of doing things up there. But I would say this is the worst I've ever, like I say, I've ever seen. It's really hard to believe this is an American court. Teresa, no one will actually know what happened. Yeah, the prosecutors don't know what really happened there. But there's an agenda to everything. Nancy, would I have ever taken this case to trial? I assume you mean if I was a prosecutor. So, no, I don't think you'll find a prosecutor that would ever take a case like this to trial, especially not the secondary murder charge. That's the real shocker. They're just way overcharging this thing. Jury verdict, the shoe has little to do with the fact that Karen Reed did not strike Mr. O'Keefe with her car. Well, not in terms of the physical evidence of that was done to his body and whether that's consistent with a vehicle strike or not, but it goes to show that there's something shady going on with the evidence, and that can be a big issue of reasonable doubt as well. Indigo, you're asking if the black soul one is a new one, the white soul is the one taken off the hospital. I don't remember which one's newer than the other. All I know is that they totally look different. The ones that they showed that was supposedly at 34 Fairview, it just doesn't look the same as the ones they have in the evidence exhibits and the ones they brought into court. And even the white ones look like very dirty when they took photos of the evidence there, and now they look like a brand new shoe, the one that was brought into court today. Leslie, you're saying I would harp on the 200 calls Jen made in a few days. Yeah, it's 200 calls. Is that the norm? I doubt that's the norm for her. Rachel, you want to know if the defense can't bring up the feds. Do you think the crash daddies can once they take the stand? I'm sure they're going to be told they can't do that as well, but they need to renew that motion to have them describe who they're hired to review this. There's no harm in allowing that to happen. The only harm it can be is to the defense, because Karen is denied a fair trial. Because think about it, they have instant credibility. If it comes out they were hired by the feds, automatically they have instant credibility, and people are going to sit up and take notice that, like, wow, the FBI was looking at Karen's case as well. So they know, they don't even have to say the outcome of any investigation, although Jen already brought it up. That's one of the reasons I think, though, they could bring it up as well. Jen brought up that there was another agency that was investigating, and they came to her and interviewed with her before she invoked, and then called them up later after admitting she lied to them. And so that, I think, would be a basis also that she introduced the fact that there's another agency investigating. So why not just say it? What's the harm in saying it? Fierce like Frida, can I review the new Commonwealth motion regarding ring cameras? I have not seen that motion. If somebody has it handy, if you want to send it to me, I'll take a look at it and present it here. Frida Reed, is the Commonwealth trying to avoid calling Proctor? They do not want to have to call him, and that may be a game time decision whether they call him or not. But they also don't want to show the autopsy photos, but they're going to have to at some point do that. So, yeah, I think the witnesses will be scaled back a lot by the Commonwealth. I think I heard some of that effect also that Karen was saying that after court today. Let me get out of presentation mode here. All right, so 1 second. Kiki, you hope that students and judges and attorneys watch this, they'll know what not to do. Yeah, this case is just riddled with incompetence and or intentional dereliction. Fruity, you're asking, will we be hearing from Colin and Allie? I think that's part of the slashing of witnesses, that Hank's not going to bring up as many people from the house because that can help the defense on cross-examination, and then he's going to try to shut him down on his cross-examination if defense calls him. Lacey, you're saying Higgins drinking and driving his high-ranking job, leaves the house to move cars to the police station at that time. Are you kidding me? I did not buy this. Yeah, I don't think anybody really would. Mr. Swampy, you're saying it does not matter why the PD switched the shoes. The fact is they did not come into the court and admit we lost the shoe, which means they're deceiving the court and the jury. It's a criminal malfeasance. Yeah, I mean, it looks like a black soul shoe to me. That's all I can say. If the defense are saying that no, they think it's a white shoe, and based on what they have in the evidence collection room, that they think it must be a photo light issue. I wouldn't take that approach, but that's up to them. Yeah. I guess go look at the beginning of this live stream and you can see what was presented in court today. You're saying both have a white sole with black on the bottom. Well, no, that's not what they're showing in the evidence. From the evidence exhibits when the two shoes are together. So Scarlett, you're seeing a picture of him having the left shoe with a white bottom. but I can post here the white bottom at the waterfall. Okay, so if you had white ones at the waterfall, then why did we have this black sold one that's there at the 34 Fairview? LES, you think the left is newer? Lacey's saying the shoe was placed later in the snow. Ellie, you're saying it shows tampering. That's what I think it is. A bad and why would a 6-foot well fit? Police officer just stand on the road and let an SUV just hit him. He'd easily get out of the way. Yeah, you can't even, I don't think, drive a SUV like that fast in reverse in snowy conditions. Valhalla, I mailed you a photo of those black sneakers from John's Facebook. One second here. Let me see what I can find. All right, so let me see if I can show this. All right, here's a photo. Looks like it does not have a black upper thing, the heel wrap coming on there. So yeah, not sure about not sure why they would have a black sole. All right, let's see. I'm going to take a few more questions and we'll sign off here. Sorry, I accidentally hit the wrong button, the wrong tab. Job time, you're saying you weren't impressed by Jessica Hyde at all. She didn't convince me one bit that the 227 search didn't happen. We did learn that the 5:07 a.m. call from Jen to Nicole Albert did happen. Yeah, I just don't think she's credible at all. I think she tried too hard to try to sound credible. She tried to make some jokes and stuff like that. She said she remembered something happened on the 4th of May because she said, "May the 4th be with you." So I just don't believe what she's saying makes any sense. Julia Nielsen, what are the biggest reasons you feel this is a bogus prosecution? Let me get out of presentation mode. There's a lot of issues here that you have reasonable doubt. I mean, every single day I've got on here and talked about how there's different reasonable doubts that come out through different witnesses. But in the end, I mean, when you stop to think about how Karen reacted to this situation that was going on with John, where John was basically trying to pull back in the relationship, wanted some space, didn't really want to talk to her that Friday before they're going out. So, and then the way the whole conversation went, and then she met with him to go out that night to the McCarthy's and the waterfall, and they seemed to be getting along fine then. But John wanted to go out and drink some more, and so anyway, it wasn't a serious relationship. It looked like from his standpoint, and they're going to a house where they don't really know the people that well. And we had Higgins that Karen went out with a couple of weeks before to go visit him anyway, and was flirting with him on some texts, and she was ignoring him when he texted her at the waterfall. So, Higgins had some kind of issue going on with John, and he apparently wanted to pursue Karen, but Karen then was rebuffing him. So, and when you look at why Higgins is texting John after 12 o'clock saying, "Why are you coming over?" with a triple question mark, that's not normally something a guy is going to ask another guy that you don't know that well and whose girlfriend you're wanting to pursue. So you just go through the whole sequence of what was reasonable and Karen's reasonableness and how she acted and how she really cared about John and was calling him up, mad at him because she thought he was cheating on her. And then she eventually fell asleep and then wakes up realizing, hey, he never did make it home yet. So she started freaking out, wanting to get help from people she thought she could trust. And lo and behold, the way she acted at the scene, you compare that to the way Jen McCabe called on 911, was whispering and acting like this is not a big deal. It's just a man in the snow. She wouldn't say who it was. I mean, you can go on and on about that 911 call. And so there was no sense of urgency really that she gave. And she said she already thought he was dead. So, and then why they would go back to Meadows, John's house, after Karen just came from there to go look for John. They're going around looking in different rooms. I mean, all they had to do is look for his shoes. I don't think Karen was that much of a fool to not know, well, hey, his shoes, he never wears his shoes in the house. He takes them off. So anyway, you can go on and on about how she reacted. Running around screaming and being all upset, crying about John's being found there inside of the yard. And then you look at all the behavior of the folks in the house. I mean, you could go on and on about the behavior of folks in the house. They all got lawyers. Everything's acting suspicious with them. Tricia Miller, yeah, the search was stamped 2:27 a.m. and marked as deleted. No amount of word salad. I can change what that report indicates. That's the way I'm looking about it. The timing of that is also around the same time. There's all these butt dials. That's another thing, reasonable doubt. All these people doing butt dials. Albert showing up to an interview at the Albert's house and all that. I mean, it was all like Brian Alberts and Jen McCabe are really running the show from behind the scenes and trying to get out in front of this narrative. That's what it looks like. Anyway, I could go on and on. So anyway, just look at some of my commentary from the past 10 days before tonight, and every day is a loser day for Hank Brennan on this. Every single day is a loser day. He's not gonna have a big win. It's not gonna get better for him. In light, you're asking, is the jury described as younger demographic? Any intel on this? That's just what I've heard as well. If they're paying attention, I think even this computer stuff, they may have a hard time paying attention to it and eyes glazing over that and taking notes. So, but I think some of this stuff, hopefully they can assess credibility good. I think they really are starting to see what Karen has had to deal with. I really think that's coming through. Initially, when I thought the videos were coming out, I thought, that doesn't look good. That can really, they could dislike her just for that. But I think the defense has done a good enough job and is very successful in presenting all the issues of reasonable doubt, how there's so many issues of credibility the prosecution witnesses have. They try to embellish their testimony to try to, in a way that looks like they're trying to hurt the defense. Hank Brennan, as an attorney, I don't think he has the kind of trustworthiness that comes across to a jury at all. I think all his objections, I think hopefully the jury can pick up on it. And yeah, Higgins did text John, asked no if is he coming over. I forget the exact words, but I remember he had triple question mark. A guy that doesn't know somebody that well, and they sort of don't like each other because he's sort of interested in Karen, and Karen was sort of interested in him, then rebuffed it. I think what was it? They just had like a couple texts between them briefly, and they met one time, but that was it. She wasn't interested in him. Apparently, she also mentioned she was trying to make John jealous. She wasn't interested in Higgins. Stevie Howell, you're absolutely correct. Younger jury's not going to buy the butt dials. So they're going to understand the tech stuff a whole lot better than older folks like me. Java time, yeah, I think it happened 2:27 a.m. I mean, do you really think that after the paramedics are there and stuff like that, anybody be sitting there, well, how long does it take to die in the cold? Because think about, why would Jen do that? Because she would have just said, Karen, he's already dead. He had no pulse. He's cold. He's not going to be with us anymore. I mean, she could have tried to console her that way. But, if Jen is being asked by Karen, oh, hey, can you search this on your phone? I mean, where would that have happened? How would it have gone down? It makes no sense. It's just absolutely another one of these really weird, outlandish things that the prosecutor wants you to believe. And I think they have this mindset that if they keep telling a lie over and over again, enough people will start to believe it. The problem is they're never going to have 12 people agree to this absolute hogwash they're trying to project as the truth. Yeah, my crazy life. You do worry when you re-listen to jurors. Ronnie's resuscitation, what happened during the deliberations. Well, yeah, that was, I think that's one guy. You can't just take his word to the bank on it. That's what he remembered. And keep in mind, they had a cop as a 4-person on the jury. If you allow a former cop on the jury, guess what? They're going to tell you, they're going to be so opinionated. They're going to say, oh, yeah, don't listen to anything from the defense. Don't let, and they can really just take it from the standpoint of like, yeah, this is what defense is really all about. Yeah, these witnesses, and they just go on down the line saying, oh, yeah, nothing from the defense is credible. Government, they just did a fantastic job. I mean, it can be so much being able to twist people's arms without even trying. And so that's what I think happened that last go round. Listen, see, you're thinking that Connor was also duped by Proctor on that Sarah Livingston interview. It looked like he just realized his reading his name was thrown in too. Yes, Miss Diesel Dude. Do I think that when the jury hears Proctor's vile text, that the jury may see the clips in a whole different light? I'm thinking that may backfire on the prosecution. I think it already has. I think it actually already has, to the extent that they now have the momentum, even with him up there thinking he's playing text of Karen, and it's making her look bad. The prosecution has looked so bad that then trickling these in, and they don't show the autopsy photos. They're duping you. They're trying to dupe you. Kiki, you're saying I think they'll totally understand the computer stuff because today's younger people haven't raised that kind of stuff. Yeah, they know how to use this stuff, but I don't know all those technical terms and the inner workings of computers and all that kind of stuff. I think what's really good is that they will for sure understand the Wi-Fi connection at 1236. You don't have to be that old to get that one. All right, normal mom, you're thinking it could be any of you guys, and that they won't stop even with tampering a jury. Ellie, you're saying Brandon has nowhere to go but down from here. Murderers, dirty cops, and a medical examiner won't play by his rules. Well, I think that what you also have, he's going to try to bring some neurosurgeon type guy out of Miami. So, but I think everything he does, the prosecutor is going to be in a position where the defense can flip the script on him. Loris, you're thinking it's a photography lighting issue. It's been discussed last year and this year. Okay, well, it's discussed, but that means it's still not resolved, and I think it's an issue. So, the defense doesn't want to make an issue because they agree with you, then that's they're doing. But I don't think that's a shadow lighting issue, and a lot of people here don't either. So if we were on the jury, I guess you wouldn't want to make it an issue. If I was on the jury and I saw that today in court, I'd be going, "Hey, wait a minute, this doesn't look right. Something shady here." Phoebe Beach, you're saying it was almost like Higgins was demanding he was coming here. Yeah, almost like he was daring him to show up or demanding or a demand type of thing. Like there was some other agenda going on. Why would he be curious about whether he shows up or not? It's not his house. It's not Higgins' house. Yeah, I don't. Just because you get acquittal doesn't mean you can sue the Commonwealth. There has to be a lot more evidence of innocence, I would say, before you can bring that kind of action. And I think, yeah, you need to make sure you win this trial first, rather than looking at what you're going to do down the road. You better win this one all the way, get a full acquittal. Warren C., you're wondering, who's paying for the tab for Brennan is $250K plus for this trial, or is it by the Massachusetts taxpayers only? No, it'd only be Massachusetts folks paying for this. Although I guess theoretically the ARCA payment is coming out of the federal treasury, which we all pay taxes to. I mean, so you don't have a tightly controlled presentation by the prosecution. He's all over the place. Nothing's in sequential order. What I always try to do is bring a case and build a case because you want to tell a story. And Hank's just like, imagine if you read a book and you're just jumping around and you got this and that and a quote of somebody being interjected every day, a couple times a day, and you're going to get to 44 of them jumping around like that, and he's not going in a whole lot of sequential order. And the one thing you do take out of sequential order and bring up soon, I guess it's sequential in the sense that like any photos they took of John in the ER where they're initially treating him, there should be photos of that. So, and then the autopsy photos, they should bring all that in right away because the jury can keep that in their minds, and then what they hear through these other witnesses, it would stick and gel better. But autopsy photos are very harmful to the prosecution's theory. Phoebe Beach, it worries you that the jury will feel bad for Ms. O'Keefe and find Karen guilty of at least one. Well, I don't think his mom came across that well, that they're going to be that sympathetic for it, or this is going to go, hey, we got to give you something. I think they should follow the evidence, and the evidence is not going to lead them to do something like that with the jury instructions, as convoluted and crazy as they are. So yeah, I think this jury gets it. I think they see what's going on. Yeah, Arca's a smoking gun for the defense anyway. I agree with that. True crime. Yeah, the prosecution, he's saying he's hit around 12:31, 12:32. When first trial, they said it was 12:45, then they backed it up like closer to the 12:31 time frame in their closing. Yeah, that's another way to say it, Reese. 11 days no autopsy info, just the defense of Jen McCabe. So if you guys want to follow comments I make throughout the day, sometimes I did several the last couple days. It's at just my name And it's at True Crime Law. In True Crime, you're saying she's already innocent because she couldn't have been at John's Wi-Fi at 12:36 when they said she hit him at 12:31. Not enough time for her to get to John's. That's what I've been saying. She's got an alibi, ironclad alibi. Yeah, I mean, where's all that 3 liters of blood he lost? That's a huge, huge issue for reasonable doubt. Yeah, you know what? Even if let's just say what I always do as an attorney, it's like I don't always look at it from like if I'm defending something, I don't always look at it from my eyes only. What I got to do is look at it from other people's potential eyes. So, for example, on this issue about the shoe, let's just say, even if it's like 10% that think it's no, these are all the same shoes, that's not an issue. But if 10% of the people think it is, and you just ignore that, you could be losing out on acquittal just for that alone. So I try to always take things and present the defense and also the prosecution. I try to encompass every person's possible angles for looking at it, because we all can review evidence differently and put different weight on it, right? But you want to have the jurors come to the same ultimate conclusion on your side. So if that's like a major issue that could like prevent the last holdout from getting you a full acquittal, and you don't bring up the shoe thing, you know, I'd bring that out. Rockways, you're saying time window for John's death has tightened considerably, almost less than a minute, and all that of this went down and more confused than ever. Yeah, I mean, there's all that activity going on there. At the time, supposedly this vehicle strike happened, and then people are still coming out of the house, driving by. There's some snow there, which make them stand out even more because it's brighter out. The light illuminates things more. Yeah, the issue is not the shoes side by side. The issues are the ones that they had taken at the scene at 34 Fairview. That were those shoes, or where's that shoe? The left shoe. For MAGA, you're saying Massachusetts was corrupt before you're born. You're 70 plus. Look up the history. Yeah, there's some really entrenched corruption. And what I've noticed is look how many people are from Canton in this trial. They've never moved away. So they're really entrenched there in the culture. Jenna Meeks, you're saying you cannot make 7 butt dials without having to touch your screen on your phone. There's no way. Yeah, Melissa L., you're another one of those that looks at it this way as well. So yeah, I mean, there's a lot of people that have the same opinion that those are different shoes. Cat's Pajamas, you're saying if you look closely at the waterfall video when John and Karen arrived, John hugs Higgins, another contract creator, pointed out he was patting him down. It sure looks like it. Andy School, you're asking, can Karen sue Coffin Daffer for calling her narcissist and murder all the time on X? Yeah, I think some of those people that have been bashing her, I think they could be looking at some of those kind of suits coming their way. Trisha Miller, there is no impact bruise on John's body from the truck, no broken bones on his body. No, there's nothing there to indicate a vehicle strike at all. It's so ridiculous. All right, just looking for Tanya, you're asking what I think about Hyde saying sorry to Hank after talking about best practices. What can be done about this? The best practice has to do with not having the phone shipped in some kind of Faraday bag or box, so it allows some kind of influence on it still. And so I just think the defense is going to say that there's a chance that things could have been corrupted after retrieved by the PD and the troopers. Yep, I think she'll get acquitted. That's what my prediction is. You've learned to never have faith in juries. They're too unpredictable. Well, I find that they're very predictable with me. If you get them the right information, present it in the right way, you show the injustice of what the other side's doing. I haven't had a problem with that. Yeah, I think you're right here, Queen Olive. Just like the first trial, the Commonwealth is defending and protecting Jen McCabe and Alberts more than proving Karen did anything. Yeah, Drea, mad respect and thanks for ARCA not only choosing to stick with this, but also sacrificing to meet today's deadline. I was really worried that they weren't going to want to stick it out and be subject to this kind of beat down by Brennan and the judge. So I have even more respect for them than I did already. They're going to crush it. Yeah, I mean, I think Darlene, you're saying why their attitude at the hospital, they both had Jen and Carrie hammering in their ears. They must have really she must have really disliked Karen. Yeah, I think that Karen, when she imitated her with that tone of voice and snarkiness about Mrs. O'Keefe, it's like, gosh, you want to be talking about the victim's mom that way. But you know what? I think she was being totally real. And I think as it's going through and you saw how she came across on the witness stand, talking about how she's been married too long and you're in a murder case for your son's murder and you're going to crack a joke right out the gate like that. So I don't think that's going to go over well. And then the fact that she's not even sitting with her other surviving son still. So I think she's lost a lot of the sympathy there. So I just don't see that she's going to have much pull in this jury thing. We got to do something for the mom. We can't let her go without that conviction of something. Bees, you're saying you lived in Alaska during my working years of 45 plus years, and blood will not soak into frozen ground. That sounds totally accurate. I agree. Andrew Mueller, John's using his phone at 12:31, and she's at their house at 12:36, not guilty. Yeah, he's even to 12:32-ish. 12:32 and some odd seconds. Yep. Another monitoring. Weather guy said ground was impermeable. So where's all the missing blood? Rosemary, you don't believe he was for a second down by the flagpole at 32 Fairview and Karen dropped him off. The other thing that reasonable doubt is like that Ford Edge that showed up. It was there when this lucky the snowplow driver came by and then was gone when he made the return back on the other side of the street. That's like really strange. Really strange. That's a huge indicator of reasonable doubt right there. Yeah, some of you guys asked him about a pull for the shoe. I've never done a pull like that. I'll have to see if that's something I can figure out here. Molly, you asked, did I notice how the cops pulled out the shoe, covered key areas? Yeah, I think that's another indicator. I think something's suspicious here, really suspicious. That's why I'd pursue this inquiry in court. If this was my case in Texas, anyway. Teddy T, asking my experience of jurors care more about it than experts' likability over knowledge. I think likability is something that always helps with any credibility of who you're bringing to present your case. So I think a lot of times experts, if they don't have likability, they're probably not going to be hired by too many people as experts per se, but then you can get some really bad ones as well. Really bad ones. So So yeah, I would say if I'm going to call an expert, I want them to be credible. I don't want to get some person that's just going to say whatever just because you pay them some money. Of course, that's if you can have your client afford them. Let's see. And you're saying what attorney would ever allow Karen to give interviews, no talking real? Yeah, it's just something we don't do as attorneys. And initially, I thought it's going to hurt Karen. I was really concerned for it, but it's still, I think it would go by the physical evidence. Even you have something that looks like an admission, I think she doesn't have. It's not confessions. I don't look at anything she said. Even if she says, "Oh, I hit him," just like I said last night. If you took off and were in a hurry to get somewhere, and your dog was outside, you had a little dog, let's say, and you come back and your dog is squashed and dead. You didn't hear anything. You had music on. You didn't feel anything. First thing you'd be doing is saying, "Oh my gosh, I killed the dog, our dog." And so it's just the overwhelming guilt you would feel. Same kind of thing with if somebody's in a situation with what we had here with John and Karen. Born a Hawkeye, 24 mph in reverse, drunk, likely unable to hit a moving target. Getting up to that speed in reverse, I had a classmate do it, and he took out a telephone pole, and the rear end was destroyed. Yeah, and if it's slick out, even if your car could go that fast, you're totally out of control. All right, so I'm going to go ahead. Last question. Yeah, there's a couple questions here. I don't want to. I'm tempted to put up, but I will pass. Thanks for all you guys supported this case. We posted where to contribute to the cause. I believe it was yesterday. Made a post on it on this channel. All right, so let's see here. You guys got a lot of Carol M. Who owns the Ford Edge at Lucky Saw? Brian Albert, whose house this happened at. He had a Ford Edge, but there's also like a Chris Albert, another brother of his that also has a Ford Edge. So we don't know for sure which one it was, but he was definitely convincing when he said it was a Ford Edge. All right, with that, I'm going to go ahead and sign off. So thanks for all your support. And I plan to cover tomorrow as well, just do some recap on what happened throughout the day. So another good way, another good day, I should say, for the defense. And we do not have a single day, day 11 now has passed. They do not have a single day where I would say the prosecution has won that day. Every single day has been a defense win, including from the time we had opening statements until today. Every single day is a defense win. So they're not going to be able to recover from this, folks. All it takes is one reasonable doubt. This thing is just full of reasonable doubt. We got truckloads of it. And I have trust that this jury, despite all the truth-denying efforts of the prosecution that's also approved by the judge, I think the jury still gets it. They like Karen. They don't like the prosecution, key witnesses. And that's really going to help carry the day. And what Karen did is reasonable. What the prosecution is arguing is complete, insane nonsense. So this jury's not going to be that hoodwinked. So with that, I'm going to go ahead and sign off. Be safe.